Good morning. Time set for an oral argument in a case that has been referred to us by Chief Justice Sidney Thomas from the Ninth Circuit, cause number OP 190304. Let me take a minute to introduce members of the court for those of you who don't know the court. On your far right is District Judge Olivia Rieger. She's sitting in for Justice Rice, who is recused. We have Justice Jim Shea, Justice Laurie McKinnon. On my far right, we have Justice Dirk Sandifer, Justice Beth Baker, Justice Ingrid Gustafson, and I am Chief Justice Mike McGrath. Are counsel ready to proceed? Mr. Wolf?
Chief Justice, and may it please the court, I'm Eric Wolf, counsel for the appellants, and that's the two family corporations, BEJ Minerals and RTWF LLC, or I call them the Seversons because they're my clients. It is a great pleasure to be back in my home state today with this case, which is I think everybody would agree is a very interesting case, and it's more interesting also because this all arises close to where so many of us grew up. We were talking beforehand. I grew up in Circle. The Seversons are from Baker. Mr. Krogh is from Roundup. So you've got a pretty good Eastern Montana contingent here today.
Some of us, some people consider us to be dinosaurs. So.
It's a great case. And there are a lot of different considerations in deciding it. But I truly believe all the arrows point to these very, very valuable fossils being mineral. And we start with the rule of law arrow, and that's this court's test. And it's a good test from Farley and Hart. And we ace that test because these are rocks. They're rocks. And they're very, very valuable. And very, very valuable rocks in Montana are minerals. And it's not that much more complicated. And you could stop there, and some judges stop there. They're like, all I need to know is the rule, and the rule applies, and I'm going to stop there. But if you then just say, well, what's fair? You know, what's fair between these parties? What's fair kind of in general in this arena? Well, that points to the same conclusion. So if you rule that these fossils are minerals, well, then the proceeds are shared because everybody here, not me, but everybody here has mineral rights to the fossils, so it gets shared. If you rule that they're not minerals, well, then the Murrays get it all, and that's a very significant consideration in sort of how this got litigated and whatnot. It's about sharing versus one side getting it all. But then if you think fairness, okay, I'm not just thinking about this case. What about other cases? I don't want to screw up a bunch of other cases. I don't want to make other people upset. Or get the wrong answer or something like that. And that still points to finding minerals here too, for a couple different reasons. First of all, under Farley and Hart, you look at the rock in front of you, and you ask whether it's of a rare and exceptional character. So Farley was scoria, and there was a theory by which even scoria, which I don't know why, we called it scoria when I was growing up. Maybe we just didn't know scoria. But scoria, there was a theory of how it could be rare and exceptional. This was scoria wool. And this court left that aside and said, we won't get to that. We don't have any briefing on that. Then in Hart, you had sandstone. It was just going to be used for riprap. And this court said, well, that's not rare and valuable. But we know.
So what we have here is bones, right? And
no, you don't.
Those turn to, over the centuries, in effect, rocks with mineral characteristics, supposedly. So my question is, do we have to consider all bones minerals? I would assume you'd say no to that.
No, you shouldn't.
So what about all dinosaur bones?
And you shouldn't do that either.
Well, how do you make the distinction, and this is what Judge Waters struggled with, I think, a bit. How do you make the distinction between some dinosaur bones are minerals and some aren't, and yet they all have the same characteristics, theoretically? Because we don't do that with oil. You know, some
Sure.
oil's valuable, some's not. We don't do that. We don't do that with natural gas. We don't do that with gold or whatever other kind of minerals that we deal with here in
Sure.
Montana. So why do we carve out a separate exception for dinosaur bones?
So I have several responses. I'll try to remember all of them. So to be clear, first, under your case law, we're not asking for a dinosaur exception to anything. We take Farley and Hart exactly as you wrote them, and you relied on a Texas case involving limestone. And in all those cases, with limestone and sandstone, you said, and you recognized there could be other situations where I've got limestone that's very, very valuable, and it's going to be a mineral. So the premise of it's either a mineral or not a mineral for anything in that category, you've already rejected that. I don't need to come here and argue for that. You've already rejected that, and appropriately so.
Well, Counsel, in Farley and Hart and the Texas case upon which we relied, Heinitz, you don't follow it exactly because at several points in your brief you talk about items or objects being rare or exceptional. We never said that, and this is kind of following up on the Chief's case. That's what you're asking us to do here. What they said was whether the substance was rare or exceptional. And in this case, the substance is francolite and hydrolapatite, or however you pronounce it. I mean, that in and of itself, I take it you'd agree, is not rare or exceptional, because that's where you get to your point that some dinosaur fossils are minerals and some aren't. They're all made of hydrolapatite.
Right. So you know, a Dutch museum is not going to pay $15 million for a bag of hydroxylapatite.
Exactly.
You don't want that test. What you just described, you don't want that test, because then you've got a big problem with any kind of precious stone, any kind of unique, like water-eroded piece of limestone or something like that, where the whole value is how it looks, or maybe what it says about the history of the earth. Take a G.
Well, so what you're kind of saying, though, is that Michelangelo's David could be carved out of sandstone, and if it's found buried on their property, you would have mineral rights to it, because even though the sandstone does not have any rare or exceptional value, the statue does.
I like that. He did say something like that, didn't he? That it's all in the marble, and I just find it. So just to be clear, that anything man-made is out because it has to be naturally occurring. But let me give you an example of naturally occurring. Let's say out in eastern Montana, you have these gigantic sandstone kind of monoliths. They're like Stonehenge, okay? And they have caves eroded into them, and my parents have some of these on their property. And let's say you go into one of those caves, and just because of the water, not because of anything related to minerals, but just because of the water erosion, you've got in that cave the exact likeness of the profile of, you know, fill in the blank, Abraham Lincoln, Marilyn Monroe, Jesus on the cross, Virgin Mary, whatever it is, it's right there in the sandstone. And you cut one of those away, and it's just Honest Abe all the way back. And it's an international phenomenon. Every museum wants one. It's the most amazing darn piece of sandstone you've ever seen. That is a mineral, okay? It's rare and exceptional just because of how it looks, just like the Hope Diamond, right? We smash up the Hope Diamond into sand.
But
It's not worth $500 million.
councils, the value is not in the mineral.
Right, but for the Hope Diamond, the value is in the shape and the blue color and how it looks. You do not want a rule. You do not want a rule that's going to take your precious stones and gems and any other natural oddity. Geodes, I saw a geode recently that was $32,000 because it was a beautiful shade of purple. So you want those things to be minerals because at the end of the day, what a mineral right is a lottery ticket under the ground. I give you the property and I say, you know what, if there's valuable rocks under there, I am retaining my interest in that. And to sort of put a point related to this case, I think that Mrs. Murray, when talking about finding the dinosaur, said everybody would say this. She said, it was like striking oil. Indeed it was. That is a very appropriate analogy. It is like striking oil. My understanding is there are like 50 T-Rex specimens out there, but there are only 12 that are like pretty good, like pretty complete. That is like striking oil. Finding one of those is like striking oil.
So counsel, in Farley, we also relied on Holland, which is out of Oklahoma. And Holland says when you have a general reservation like we do here of a mineral interest, that we look to the enjoyment of the mineral interest estate or whatever, and also the surface. And if we say that fossils are minerals, what does that do to enjoyment of the surface estate here?
I don't, so Judge Murguia on the Ninth Circuit was concerned about that too. And she compared it to the issues with limestone, which the Texas Supreme Court has also mentioned. If I call limestone a mineral in some case, and it means that you're just going to tear open the surface estate and have a quarry for limestone, I'm not very inclined to call it a mineral, especially if you're just going to use the limestone for construction or something like that. So I think that is a concern, and that is an appropriate factor when you're thinking about whether something that's fairly common is going to be a mineral. But just to be clear, and we're not saying all dinosaur fossils are minerals. They shouldn't all be minerals.
But you've got to find them. And the finding them, the excavation, won't that destroy? Isn't the natural implication of your reasoning that the surface estate is going to be?
Nobody is strip mining for dinosaur fossils.
Can you graze cattle on ground that has been excavated and once that mineral estate can recognize the interest in the fossils, that they have the right to explore the whole surface.
I guess I don't know that follows, and that would be a reason. That's a very, very important reason why you should agree with me that not all dinosaur fossils are minerals.
You don't know it until you've dug it up.
But what you're hypothesizing is a situation where I'm just out there kind of strip mining for any fossil I can find, I'm sure you don't just allow complete destruction of the surface area of property for people looking for oil where they don't think there's any oil. So I think your case law on that, I'm sure you have a lot of case law on those types of problems, and you can bring that to bear here. But this goes also to my last fairness point, which is your hypothetical is not going to arise because the legislature changed the law. So if the legislature hadn't changed the law, some of these hypotheticals maybe are a little more difficult for me. But if that's a concern, that's not going to happen. So you're really looking at, for these parties with $30 million dinosaur fossils, are you going to have them share the proceeds or not? And it's whatever you say here is not really going to apply any broader in the state of Montana because the legislature has now made it clear that going forward, the fossils are not going to be minerals.
So I want to go back to the Chief's question on the distinction between some dinosaur bones and others are not. You started down answering that and then got some other questions. Did you get your complete answer out?
Yeah. So you should not hold, we're not arguing, and you should not hold that all fossils are minerals. So, and this goes to the definition of the test for minerals. So if you imagine like let's like a Venn diagram. So we take the first circle is it scientifically a mineral? And here there's no dispute about that. It's francolite and hydroxylapatite, whatever. They're rocks, okay? Are they rocks? They're rocks. All right. Then you draw your second circle.
Well, but as was pointed out, I mean, that's what our bones, even living bones, are composed of.
That is false. That is false. Our bones have living tissue in them, and this is a process.
It's primarily calcium hydroxylapatite and collagen.
They share that, but there is no equation of these rocks that are over 200 million years old, and any kind of human remains, any kind of mammal remains, anything like that. Like, that's just not an accurate factual statement.
Well, what about the human remains that are, there was the reference in the Murray's brief to the 12,000-year-old baby. I mean, what if what had been found here was a settlement of 10,000-year-old native people settlement, and you had, let's say, human remains, and I go back to the stone pottery that's found buried on there that has been, been part of the earth for 10,000 years. The substance that comprises that pottery, the substance that comprises those human bones, would be primarily minerals.
We don't need any primarily here, okay? These are rocks. What you're hypothesizing has some of the similar substances, primarily in there or something, but they're not rocks. So you don't compare the.
Well, the stone pottery would be rocks.
Yeah, but so the stone pottery is a different issue because in nearly all definitions of minerals, it has to be naturally occurring, and the stone pottery is man-made. So the pottery's out.
But it's what the pottery is made from, just like what is the fossils are made from here.
But okay, so the only thing that would make it valuable is that it's evidence of human civilization, and it was made into a certain shape. But none of that was naturally occurring, so that can't.
So the fact that what makes this valuable is that it's evidence of ancient creatures.
Which is very valuable.
And and that are ancient creatures, and that it's because it's naturally occurring. That's the distinction. Is that?
Yes. And we know so this is. We have a test which is your test, and you can apply it and you can answer these questions. Okay. The other side really can't survive any kind of logical question, because if you go down this path of but it's bones, but it's biological. Okay, fossil fuels are from fossils. We know that. I mean, the Sinclair gas stations used to have a big green dinosaur. Like that, they run into that roadblock right away. So they can't go down that path. If you want to go down the path of, well, you got to be using it because of the minerals. Well, you've just thrown out a lot of precious stones because they look nice. I mean, people have fancy countertops made of these things. You don't want to go down that road either. I can answer these questions with your test that you've already adopted. You do not need to change it. They want to make some dinosaur exception to that test that then screws up your law in lots of other ways. And that screw up will keep applying in other cases if you do it. Whereas for the dinosaurs, the legislature's already answered it. It really doesn't matter. At the end of the day, the only thing here really is fairness between these parties. If you can keep your tests you already have.
So it's been certified, and this was brought up in the Murray's brief, the question that's been certified, and they say, and I take it based on your argument, you agree that the question that's been certified to us has to be reformulated or you lose.
Yeah, that's fair. But the question you've been asked is absolutely not a question you should answer. I mean, your own case law is your case law has been very careful about these things. Your case law has recognized that, it can be really hard to answer these questions in certain cases. We're going to kind of go case by case. And then you get this question from the Ninth Circuit. It's tell us if all fossils are minerals. No, you didn't even answer whether all limestone or sandstone is a mineral. Why on earth would you answer it with respect to something that's worth so much more? If I had to choose between the best limestone in Montana and the best dinosaur fossils, I would take the dinosaur fossils every single time. They're much more valuable rocks. So I was thinking about it this morning, and I don't want to be overly flip, but if you want to talk about the ordinary meaning of a mineral reservation or a mineral, the lottery ticket under the soil, and if you can take your rocks to New York and Sotheby's auction and the opening bidding starts at $6 million, which is what happened for some of these fossils, or you're at the Hilltop Cafe in Jordan and you're taking calls from a Dutch museum that wants to pay millions of dollars for your rocks, guess what? They're minerals.
So, counsel, can you address the fact that neither party in the conveyance contemplated fossils as part of the mineral estate?
I think, and I can talk to my colleague when I sit down, and if I make a mistake, I'll correct it when I get up on rebuttal. I think it's conceded that nobody was thinking about it. So, it doesn't help either party.
Well,
How can it not, though? At the end of the day, this whole concept of mineral rights is a contract interest.
Correct.
And it's a fundamental tenet of contract law that the terms of the contract are based upon what the contemplation of the parties were at the time the contract was formed. So if there's no contemplation of any conceivable potential here of finding rare dinosaur fossils, how can we have an enforceable contract from that standpoint that encompasses that substance that was not contemplated?
That's interesting.
well, and I'll add, I think that the conveyance should be construed narrowly. It's a reservation of the mineral estate.
So this is in 2005, and I think the easy answer is when it reserved minerals, it reserved what this court had said in 1995 in Farley.
But we've never passed upon, and nobody has ever passed upon the issue of whether fossils are minerals.
I appreciate that you recognize that nobody has passed upon it because.
So that goes back to, this is kind of like Potter Stewart, I know when I see it. If you're just asking someone on the street, just back to your point that you don't go to the Museum of the Rockies and say, hey kids, we're going to see a bunch of hydroxylapatite.
Right, but we're looking at some really valuable rocks. We really are, and the Potter Stewart analogy is very good. That's their test. That's their test. Let's just sit and think about ordinary meaning for a while and decide. You've already got a very good test. It's the same test that other states are applying. Big circle, are they rocks? Next circle, are they rare and exceptional? Where there's overlap, it's a mineral. That's the test, folks, for what's a mineral. And it's
So
a
are you
test.
saying then that the contemplation in the contract then was that there would be, that anything that had a mineral content that we then looked at was rare and valuable would be included in that would be the contemplation
That's
in the
exact-
contract?
That's exactly right. So that general reservation, to go back to your question, it doesn't need to contemplate anything in particular, but it is contemplating, if you find that lottery ticket in the soil that's a rock, I am reserving that. And I'll leave you with this because I've been talking for a while and I want to have some time on rebuttal. We cited, when we made the Hope Diamond analogy, we cited a Kentucky case that was exactly like your question, where one party said, we were thinking about silver and nobody was thinking about diamonds. They shouldn't get those diamonds because nobody was thinking about that. And the Kentucky Supreme Court said what you all should say, which seems to me fundamental to the nature of creating a test for minerals that people can apply. It doesn't matter if you were thinking about diamonds, because we know diamonds are minerals and they're rare and valuable and they meet that test. And the same is true here. It doesn't matter if anybody was thinking about fossils or gold or anything else. My clients reserved valuable rocks. You find valuable rocks, I'm reserving on that. That's my lottery ticket. You strike oil, I'm reserving on that. And that's the deal, and that's fair to honor that deal, and it's fair in this case because that means they share the proceeds. So I've been talking for a while. I'll reserve and come back and answer more questions. Thank you.
Mr. Krogh?
May it please the court, Harlan Krogh, along with my co-counsel John Christ, on behalf of our dear clients Elijah and Marianne Murray. I want to start out talking a little bit about the certified question, but I think I listened for about 25 minutes about rocks. And I think that the discussion about bones and rocks are probably the most fundamental part of this discussion. These aren't rocks. And unless you take that illogical leap to transfer a bone from a once living animal who roamed this earth and then somehow mystically create it as a mineral, like a chunk of coal, just cannot be logical.
Well, isn't that the
Use your
same
common
as
sense.
getting oil? I mean, it was a once living creature that through a natural process turned into oil?
I appreciate that, Your Justice Gustafson. That's a question that's often asked us, and it's a misconception. Oil doesn't come from organisms. It comes from plankton. It comes from algae. It comes from a geological process. You can Google it. It is one of those misconceptions that we have allowed to proceed that gives us the wrong conception. Oil isn't from dinosaurs. It's from a geological process of plants, plankton, organisms that die, go to the bottom of the sea, are pressurized with heat.
So living organisms that go to the bottom of the sea and have a process and are converted into oil.
Organisms that only survive in terms of in water, in plants, in that sense. So
But how is that different from a living organism that,
I think it's a huge difference between a living animal, like a dinosaur, and an organism that is only a part of plankton. Okay? These are not rocks, and there have never been rocks, and they never will be rocks. The Ninth Circuit asked you a very concise and appropriate question, whether under Montana law, dinosaur fossils constitute minerals for the purpose of a mineral reservation. The answer to that question is easily said no. Unequivocally no, emphatically no. You have never, and Montana has never recognized dinosaur fossils as a mineral, and it never will. We know now, under HB 229, that the citizens have spoken about the answer to that question. But
So, Counsel, is the only precedent for this that Earl Douglas decision, which wasn't a court decision, but from the Department of the Interior, that addressed specifically the issue of whether fossils are minerals?
I think that's the clearest precedent. I think the fact that that is in harmony with everything else, how we've treated dinosaur fossils in our statutes, in how we have come to a common understanding between fossils and minerals. But Earl Douglas, yes, 100 years ago, and which everyone has relied upon for the last 100 years, have said, we treat dinosaur fossils on federal land differently than minerals. We don't consider them to be minerals. What the appellants are asking you to do now is to make a finding specifically just for this case, that would be directly contrary to Earl Douglas. And we believe that that would be incorrect in doing so. One of the things I think that you have to start in the analysis is categories of things. And it may sound pretty basic, but we understand substances by categories. That's how we teach our children, our grandchildren. We teach them there are certain things that we just know are true. And some of them are really a basic 20-question game that you can play. And you talk about animal, vegetable, and mineral. And if I'm playing 20 questions with my grandchildren, and I say it's a mineral, and it ends up being a dinosaur fossil, I think they're going to be pretty mad. I think they're going to feel like they got fooled.
Now you're sounding like Potter Stewart.
Okay? I may be. But there are certain characteristics that we know are common in minerals that are not in a dinosaur fossil. How we display things is a way that we consider things in their categories. In the Museum of the Rockies, how do we display a dinosaur fossil? As a living animal, as a skeleton of a once living animal that walked this land. We don't put them in the room for rocks, right? We don't have them in the Museum of Mining in Butte under the rock collection. Of course we don't, because we know that they are bones. We know that they are evidence of life. There are other examples in terms of how we know that they're not rocks. Rocks are substances that are inorganic in nature. They're created not from once living animals, but they are homogeneous matters that are created through geological processes. We know that a scoop of coal is just like this. It's the same no matter what. Dinosaur fossils are different in their character, in how they're found. And there are other reasons as well. We know that minerals are generally mined. They're extracted. They're done on an industrial level. They're processed so that we can exploit them. Fossils don't fit that definition.
Counsel, your arguments are going to the portion of the test that we've applied addressing the ordinary and natural meaning.
Right.
And unfortunately for your position, there's the remaining part of the test, which is that the exceptionally rare and valuable.
Right.
So can you analytically address how that test, particularly the exceptionally rare and valuable, applies or does not apply here?
Good question. In order to get to that second part, which is the part that you'd like to talk about, you have to have a group of substances that are actually minerals. And remember, we're talking about the ordinary and natural meaning of the word minerals. We're not talking about a scientific test. In fact, Heinz rejected that entire test. They said it doesn't work because you have too many other possible substances that would fall into that category. So in terms of dinosaur fossils, we don't get to the second part. Clearly, they're rare and valuable. These dinosaurs are.
Isn't the second part kind of what separates out? Like, you have a mineral content, and then how we determine, whether it's, to use the other side's term, the lottery ticket, is whether it's exceptional value.
I think the second part of the test in Fairley and Hart is helpful when you're talking about substances that are minerals. Here, we're not talking about substances that are minerals.
So you would apply the ordinary and natural first to say it's not a mineral under that test, so we don't even get to the second.
Exactly. And Judge Waters found the same way. She discarded and rejected the scientific test because we don't really know what the scientific test is. In fact, is it the battle of scientists? Is it the battle of experts? We don't know what that real test is. But we do know that the ordinary natural test is the more appropriate test for a few reasons. One, Heinz told us that. Secondly, it goes to the natural meaning of the conveyors, the people who are transferring the mineral rights. They're going to understand what minerals mean, not by a scientific test, but what's the common understanding of that word. And that common understanding is what bridges our communication, how we live. Isn't the law supposed to be the common understanding of certain things? It gives us predictability. How can we expect a farmer or rancher to know the scientific test of a mineral when they're transferring a mineral deed? We don't.
Mr. Crow, the Ninth Circuit, in the panel opinion, which the en banc order incorporated or attached anyway, says the parties do not dispute that the Montana fossils are minerals in a scientific sense, as they are composed entirely of the minerals hydro whatever and or frankylite. And now it sounds like you are disputing that.
We never did stipulate to that. We never did agree to that.
You never agreed that they are minerals in a scientific sense.
No, we did not. I don't even know what scientific sense is. We agree that
Well,
there are
don't we
mineral.
have, I mean, earth science, and certainly you went to a variety of earth science and other classes like that along your way, and we have a pretty well-known definition of minerals in a scientific standpoint. And you're saying that's just not true?
Well, no, I'm saying that when we use the word mineral, our English language sometimes is difficult. We have a big group of substances we call minerals. We also have mineral ingredients. Are things containing mineral ingredients? Absolutely. We all are.
So it
I stood-
focuses on a substance's chemical composition. I mean, and these substances comprise chemical compositions at the scientific level.
They do. But that was not the test that you should apply. We've rejected that test. Nobody has, Farley hasn't accepted that test. Hart didn't accept that test. Judge Waters didn't accept that test. She went to the ordinary and natural meaning of the word minerals.
Council, I have a question. My neighbors in eastern Montana, you said you would expect ranchers, farmers to know what minerals are when they're making these mineral deed reservations. And I guess I beg to differ with my neighbors out there in way eastern Montana, past Billings, no offense to Justice Gustafson. But how does that go with what Justice Sandifer was asking, where you're expecting people to make certain mineral reservations, such as dinosaur bones, and then turning around and saying, well, they know what they're reserving? Because many times farmers and ranchers in Montana reserve those mineral rights to last long after they sell the surface rights for their ranches, in hoping for coal and bentonite, oil, things like that. So how do those two mesh together when you're saying one thing on one end and another, expecting these ranchers at the Hilltop Cafe in Jordan to know what they're reserving?
What I'm saying is I think that the law should be, and it is that we look to the common and ordinary, natural, popular definition of these words.
As long as the ranchers know what they are.
And ranchers and landowners and people in Montana understand fundamentally the difference between a dinosaur fossil and a lump of coal.
But you also said that coal, you extract it, and we exploit coal, we sell it. These dinosaur bones, fossils, were extracted from the ground, and they were surely exploited for no Montanan to enjoy. I'm never going to make it to see these fossils, so how can you say that they're not treated like coal or bentonite or oil?
Good question. A couple of reasons why. One, they're not mined in the traditional sense. They're not mined and processed and milled and smeltered like we know our great state. We have a seal. We have a great history of mining. Some of that is a very storied history. We understand mining probably better than any other state around us because we have great things about that mining and we have environmental concerns about that mining that we're still dealing with. So we know what traditional mining is. When you find a dinosaur fossil laying on the ground or somewhat buried in it, it's completely different, even in terms of the common man. I think that they understand that. They also understand that there's a vast list of things that are rocks. They're coal and oil, or coal and uranium and ore and those kinds of things, and they've always traditionally been minerals. And I think everyone understands that. And our laws are supportive of that. Your statutes, when we talk about mining, we talk about ore and rock and uranium. We don't talk about dinosaur fossils. We have been consistent with that. In fact, we've talked about it in terms of our taxation. We've talked about it in terms of our mining. And when there was times where you could differentiate between the two, the legislature has done that. In the Natural Historical Society Act, they've made those distinctions where they said, no, there's a difference between minerals in the traditional sense and finding dinosaur fossils.
Do you have to have a permit? Do you have to have some sort of like antiquities permit or something to dig dinosaur fossils in Montana?
Maybe you do.
In other places, maybe
Yeah,
But you do have to have a permit to dig all of these other,
right, you do, and that's subject to the Mining Act, subject to all of the different regulations that we've tried to impose on that kind of activity.
Mr. Krogh, can you address how and whether this court's decision in this case will impact other situations in light of the new legislation?
I'd like to do that. HB 229 simply answers the question of what the law is. If you want to answer the certified question, that is the answer, that dinosaur fossils are not considered minerals. Now, would the Ninth Circuit ask you to answer that question if they already knew what HB 229 is? I think they want a little bit more. But that's the short answer. Does it directly affect our case? I don't think it can. Yes, there's a savings clause. We understand that. I think it's intended to be retroactive and prospective to the extent possible.
Okay, but beyond that, Mr. Wolf made the argument that you're going to mess up all the case law that will continue to be messed up no matter, the statute on dinosaurs will be changed, but we'll be altering our case law.
And I disagree, Your Honor. I think the answer to the certified question, whether you exclude HB 229 or not, is the same. Dinosaur fossils have never been treated or considered minerals, either before, now, or in the future. And so you're not going to mess up anything because the law has never changed. And it never
We carve out a unique exception for dinosaur fossils.
And that's what they'd like to do. They don't want you to certify, they don't want you to answer a question of law that's been given to you. That's what's been given to you. They want you to sit as a court that's going to...
That's what you want us to do.
I want you to answer the question, yes.
Right, and
Right.
carve out a specific exception from our case law as it refers to dinosaur fossils.
No, we're not asking you to carve out any exception. What we're saying is that dinosaur fossils don't meet the ordinary and natural meaning of minerals in the first part of the test. Farley and Hart are still good for rock substances, for things that can be a rock, things that can be a mineral. But you can't use the scientific test because you have other things like topsoil. Is it mineral in nature? Sure it is. Is it rare and valuable? It could be at certain places. Water, subsurface water is a mineral, has minerals in it. Could it be rare and valuable? It is often rare and valuable. It's certain.
But wouldn't our test allow us to do that on a case-by-case basis and make that determination and be consistent?
Well, that's the fallacy of the scientific test. That's what Judge Waters was saying. That's what Heinitz is saying. Don't use that test because it is too broad of a test. You have to go to the ordinary and natural meaning because we're talking about contract construction. We're talking about what the words mean in a document. And what is the test for that? Not a scientific test, it's the ordinary and natural meaning test. That's what we've always done. And what do you use for sources? State statutes? They're absolutely appropriate. The dictionary? Judge Waters used the dictionary. That's the common man's reference guide. The common understanding of anyone to start somewhere is where? A dictionary.
So the Black's Law Dictionary, though, minerals includes all fossil bodies.
That was an outdated one.
Oh, yeah. So whichever one you want us to use is the
No,
one we
I'm
use.
just saying that I don't think that dictionaries are the sole source. But there's a reason why it was changed. There was a reason why it was changed. I think dictionaries just conform and they affirm the statutes, the case law, and everything else around us that says dinosaur fossils are not rocks.
Counsel, can you address what Holland and our reliance on Holland? Specifically, it says the intent should be the general intention from the standpoint of enjoyment of the respective interest created. And they're talking about the respective surface right interests, being able to enjoy that,
Right.
and being able to enjoy the mineral estate interest. And what is going to happen to the surface rights here if we were to find fossils or minerals?
Well, if you find that fossils are minerals, then the surface rights are going to be violated.
I want you to be specific.
Okay. Well, I think that you are giving, the people who have the surface rights are giving up rights of enjoyment that they never intended to. Meaning they're going to give up access to their property. They're going to give up the destruction of their property. They're going to give up the entire context of their property as they know it, as they can use it, as they can enjoy it, will be dramatically changed. Here's the thing about HB 229 as well. That's the law. But Judge Waters also got it right too. She understood and in a really thoughtful analysis went through the basic steps of how we determine ordinary and natural meaning. And I think at the end, she said, through all of this consistency, everywhere that I look, in statutes, dictionaries, case law, federal law, everything is consistent because everybody has always considered dinosaur fossils not to be minerals. She uses the example of a mule deer bone. No reasonable person in Montana is going to believe that that bone is a mineral. And that's why her analysis is the correct analysis. On one hand, I've got 3 minutes, and I'll try to sum up some things that I think are important. You have one job to do, and is to answer a question. Unfortunately, you have two distinct paths that you can take to do that. On one hand, I think you can disregard the Ninth Circuit's question and recertify it only to affect these parties, which really disregards the public policy considerations that the Ninth Circuit was trying to announce to you, that this is bigger than these parties. This statement of law means much more to museums, landowners, paleontologists. It's a statement that they can rely on.
Is that true in view of the retroactive application of the new law? That it's going to affect all these other potential?
I think it is. I think it is, Your Honor, because we don't know we don't know how retroactive this is going to be. That's going to be probably litigated for another day. What the Ninth Circuit wants to know is, what is the state of the law today? And if we disregard that and we only try to make a decision based upon these parties and who's going to win, I think you're going against what the Ninth Circuit has asked you to do. You can disregard the ordinary and natural meaning test and try to craft a scientific test that's been rejected by Heinz and by Judge Waters already. You can try to deviate from the common knowledge and common understanding of what we classify minerals and bones in a different category. You can call a bone a rock, but it's truly not a mineral. Or you can answer the question posed. You can understand that there's broad ramifications for it, that you're not just deciding this case, but you're deciding the statement of law. You can recognize the thoughtful and sound reasoning of Judge Waters, and that she found that dinosaur bones are not minerals like coal, ore, silver, and others. You can apply the right test and maintain Farley and Hart. And you can recognize the common understanding of the citizens of Montana as they spoke through the legislature. That's their voice. That's the only way that they can speak. And it's clear and it's concise as to what they believe dinosaur fossils are. With all of that, we respectfully and humbly ask that you find the question that dinosaur fossils are not minerals under Montana law, under the ordinary and natural meaning of those words. Thank you for your time.
Wolf.
Didn't bring my binder, so I wouldn't have another spill.
We're not worried about it, don't.
Mr. Wolf, I want to follow up with you right out of the gate. From earlier, you went back repetitively to this analogy of the Hope Diamond and talked about its unique and valuable visual characteristics. But it made me think about this a little further. All diamonds are minerals, and very few of them are valuable. There's industrial diamonds, they have value, but a great many diamonds have no value whatsoever. They're waste in the mining process, but they're minerals nonetheless. So I don't see how that analogy fits here, where you have already conceded that all dinosaur fossils are not minerals.
Okay, so I think we have some things that are going to kind of always meet the legal test, the rare and valuable test for minerals, gold, diamonds. I don't know if diamonds can, reach a point where they're dust, and they're not going to be valuable enough. Like if you crush the Hope Diamond down enough, now it's just sand, and it really is worthless, and it wouldn't meet Farley or Hart. I don't know the answer to that.
No, what I'm saying is that when they're mining diamonds in South Africa, a great quantity of the diamonds that they pull out of the ground are worthless waste, because they're not valuable as either industrial diamonds, or they're not valuable from a jewelry or other
Sure.
unique standpoint.
I don't know.
They're diamonds nonetheless, and nobody could contest as a matter of law that just because they're worthless waste at the mine, that they're not minerals.
I think you could actually, because, let's say the diamonds you're hypothesizing that are worthless, they could be like the scoria of diamonds or the riprap of diamonds. I don't know. I don't know that much about them.
But so, counsel, this goes back to, following up on that, then, what you would want us to answer is to say that, in this case, some are, some aren't. So using the diamond analogy that Justice Sandifer was talking about, if they had hit upon a vein of diamonds here, then it's going to have to be, well, let's let the court decide whether this one is a mineral or not. Let's let the court decide whether you've got the rights to this one. I mean, how is that tenable?
Well, I think, practically speaking, you're going to have some things like diamonds or gold or copper or whatever it is, where they're going to meet the test every time. And this court's case law will have already answered those questions. And, here, like, as time goes on.
But they don't meet, going just on that analogy, they don't meet the test every time as you interpret our decision in Hart and Farley. Because if you say, okay, they passed the first leg of that test, but then you get to the second leg of the test, which is the unique and exceptional value, you're asking a court to decide on a case-by-case basis each time you have, well, this one is, this one isn't.
Right.
Let's let a judge decide.
Here's the reality, though, and here's why you want to do it the way that I suggest. You don't have cases litigated over the worthless stuff. You don't. You get cases litigated over the lottery tickets, the $30 million fossils, the diamonds that are actually worth something. And then you might have to, flesh it out.
Well, in Harley and Fart, we found, Farley and Hart,
Glad
sorry.
glad you did that and not me, so.
Should have practiced that one. We had found that the sandstone and the scoria was worthless. So there was litigation over the worthless stuff.
Right, but but that's a little different because, it's not worthless, right? This goes to your strip mining example, like, you can truck it out and make money on it, but that's going to interfere with the service estate, and it's not kind of acutely valuable in the way that we use for minerals. And I just want to go through, I have like a few items that came up, and to go to a question that's asked, I thought it was undisputed that they agreed these were minerals, as a scientific matter. I really thought that was undisputed. Mr. Krogh made some of these same arguments in the Ninth Circuit, and he was shut down by Judge Milan Smith, who said, I have a geology degree, and what you're saying is just wrong. And that, I think that might be why the opinion was kind of written that way. But I will take, if to take his line of argument, I think I am more than happy to take a Montana school child test if you will give me a school child who's been to the Museum of the Rockies and is at least a B student. Because, as we put in our reply brief, right on the placard, they're rocks, okay? It says right there, in replacement, the original organic hard material is completely replaced by minerals. And I think a typical Montana school child, if you said, now, are they still bones or have they become rocks, is going to say they're rocks, because they are rocks. And the Museum of the Rockies is the leading institution on this, and they explain it there for everybody to see, and I thought it was undisputed. On the old,
Everybody refers to them as bones.
because they once were, sure.
Yeah.
Yeah, that's fair.
So doesn't that go back to the contract interpretation of what the parties were thinking when what was the meeting of the minds when they reserved mineral rights?
The meaning of the mines is my clients, and for them, they have mineral rights too. If you've got the really valuable rocks, if you've got the lottery ticket, I am reserving on that. And their client said it. It's like striking oil. And that's a very fair analogy. There was a question.
Nobody ever says, Eureka, I struck dinosaur.
It will. I bet somebody has in eastern Montana. Like I said, when you're at the Hilltop Cafe having your phone call with like the Saudi prince who wants a T-Rex in his rumpus room and will pay millions of dollars for it, like, that's striking it rich. That's striking oil. And just to, this is important. These things change, right? Like, you give these old analogies we all know, okay? Before nuclear power, uranium was worthless. Now nuclear power is worth a lot.
But Counselor, your
Things change.
test seems to boil down to, if it comes out of the ground, it's not man-made, and it's extraordinarily valuable, it's a mineral.
And it's in that scientific mineral category. Yeah, you've got it.
Which is everything on the planet.
No, that's not right. No, the scientific test for, like, truffles come out of the ground, they're not minerals. Tulip bulbs, potatoes, anything man-made is out because it's not naturally occurring. So I'm not saying you've got all of Earth and everything in it, and then we just look at what's valuable. That is not my argument. Can I just say a word about museums? Because I think it's important to mention the museums. Would that be okay? So I think the Ninth Circuit got spooked because they got this amicus brief from Covington and Burling, which is a very good firm in Washington, D.C. You have it. We've debated whether you should read it.
Make your point.
Okay. There's no threat to museums. Most of the fossils in the Museum of the Rockies, 90% are from public land. The law has been changed. They haven't pointed to a single fossil anywhere that is going to be threatened by what we're arguing here today. That has been scare tactics, and this court should reject it. Thank you very much for the extra time. Thank you.
Thank you to all counsel. This is indeed an interesting case. We will take this matter under advisement and